So they've grown up with computers. I have this graphic of the person with their computer screen, and I'm talking to you through technological wonder. When I went to law school, almost 40 years ago, there weren't any computers. There weren't personal computers or desktop computers or any of that type of stuff. So we've seen an amazing technological evolution. And as part of that, we have e-commerce, business to consumer, business to business, international transactions at a push of a button, people starting businesses through what we call clicks over bricks. It's easier to start a business on the web than to get financing and build a concrete structure someplace. It's more maneuverable. And so we have electronic commerce that is pretty much part of all of our lives. In fact, it's been so expansive that we now talk about the Internet of Things, which is a cliche that relates to everything being tied to computers. Your phone is really a computer now. Travel, just lifestyles, everything being internet related. And that is something we're moving toward. And as we move toward that, then we have to think more about intellectual property concerns, because intellectual property usually makes people think about the aspects of private business, but there are lots of public intellectual property concerns as well. I think we all know that more so than ever. We've all been sensitized to that in recent times, for instance, with the intellectual property related disputes for COVID vaccines. Those types of things are public intellectual property matters that are the subject of different talk. But we do have trade-related intellectual property rights, TRIPS, which is a treaty that only became effective in 1995 for the most developed countries, and some countries are still working up to the status for it to be applicable to them. I know it was said that we'd, I'm sorry here, just momentarily lost the picture. Oh, hold on. I know it was said that most people today are familiar somewhat with intellectual property. And just to get us all through this on the same, with the same mindset and the same foundation, just highlighting at least when we think of intellectual property at its base, we think of patents, which deal with inventions, copyrights, expressions, trademarks, identifications. That's how I start off fundamentally, so that people have some shorthand reference to what IP is all about. Trademark laws is more expansive, dealing with unfair competition. Also, trade names, trade dress, trade secrets. Anytime you hear trade, people put that in with trademarks. And we could see that the other areas could be more expansive as well. All of these laws are nation state specific, even though there are international treaties like TRIPS that I just mentioned that have an important role. But TRIPS in and of itself isn't binding as law on nation states, all of the signatories to it. This is our symbol for our U.S. Patent and Trademark Office. We have a different office for copyrights in the U.S. and obviously the symbol for the Intellectual Property Office in India, and a couple of universally recognized symbols, trademark, meaning that somebody's claiming rights in the name or the identifier for good or service, and the C in the circle for copyrights. We also have the R in the circle, which is related to trademarks, and the P in the circle, which people see a lot and assume to be a patent, but it is also a copyright sign and not indicative of a patent. Patents are usually identified by numbers, and we'll see a patent shortly. But just to cover briefly other areas that, again, could all be focused on if you were doing a breakdown of IP and e-commerce, copyright law would be important because computers don't operate without instructions. So software is literally written expressions indicating what the computer should do, and therefore it's protectable under copyright. So are other types of code. All of this used on websites. When we're looking at websites, what you're seeing right now, images, graphics, if I had incorporated some audio or video portions, that's all copyright related information that I might draw from or put together as a database, which are parts of the websites, and an important aspect in e-commerce as far as indicating what goods or services are available to the consumers are also protected by copyrights. Then any sort of distinguishing identifiers, logos, symbols, signs, etc., trademarks. Another aspect of intellectual property law that is fairly widespread throughout the globe, but not part of the U.S. Intellectual property scheme is industrial design. And industrial design can be used to protect screen displays and the other items identified there as well. And then patents protect hardware, search engines, technical tools, and business methods are important. Here's an example of a patent owned by Intel Corporation, and you can see it's identified by the country and the number showing what patent was issued. And it's a patent for, as it says here, facilitating electronic commerce through an automatic database, reputation characterization. So this is an e-commerce patent, one of many that are out there. And these patents can give rise to some quite protracted disputes. And so here's an example of a couple of patent disputes that recently made news in the US and possibly throughout the world. We have IBM, International Business Machines, that they have been one of the groups who has pioneered getting e-commerce patents. And your intellectual property overall is only as good as the enforcement. Like any other property, if you don't use it or watch over it, you can lose it. So IBM polices their intellectual property, and they sued Groupon, which is a globally recognized entity as well, and recently settled for $57 million. Groupon paying IBM, and IBM in exchange giving Groupon licensing rights so that they could use some of the intellectual property that was subject to the claim. Just last year, IBM filed a case against Rakuten for their e-commerce website that claims to connect consumers who want to purchase products from certain providers. So the patent area is ripe for dispute when you are looking at a method of doing business, which is what e-commerce is all about. Somebody files a patent for that. There's a lot of back and forth on what the scope of those rights are for that patent. And it's an ongoing area as technology continues to evolve and players want to corner a bigger part of the e-commerce market. And likewise in copyright, we have disputes ongoing. We have Apple, which everybody knows, suing Corellium here where I live in Florida, claiming that Corellium is providing virtual versions that are accessible by web browser. And so Apple says that their computer programs and graphical interface were being misused because of the packages for consumers that Corellium was providing, gave them virtual versions of some of the Apple games and things of that nature. This suit is still going on, but earlier this year, a couple of months ago, Corellium was able to win a part of the suit, what we call a motion for summary judgment, based on fair use principles. So they're still fighting it out, but so far, Corellium, the small fry in this matter, has come out with a preliminary knockdown, if not a knockout, of Apple's claims. And some of you there may be familiar with Warner Brothers Universal on Netflix bringing the copyright infringement claims, claiming that there were URLs allowing pirated copies of their shows. And the Delhi High Court said that those ISPs needed to block those users, Tamil Rockers, Lime Torrents, Sky Torrents, many others, in order that they have their domain name registrations suspended. So those are some examples of what's going on in patents and copyright area. And then there's also the trademark area, and that's where the shift is from just IP generally in e-commerce, because copyright and patents could be their own subject matter. I'm going to talk about domain names, and obviously domain names are related to trademarks. So all of this web traffic that we talk about in these e-commerce infractions that people are giving rise to, are using to give rise to disputes, are based on websites. And websites, they have the look, the feel, they have the location. As I said, it's where trademark law and domain name law intersect. It all begins with the website. And so, first and foremost, domain names aren't automatically considered protectable trademarks, and somebody's trademark isn't automatically their domain name either. So domain names has developed its own area, and that's related to the domain name being the address. We talk about the internet and the web, and we all know that it's a function of numerics, in the sense that that's how computers operate. But there is the correspondence to words and language that's involved. And so we have these uniform resource locators, URLs, and they are addresses, and they are overseen by the Internet Corporation for Assigned Names and Numbers, ICANN. And so I have an example here of URL and the part of it. You see that it indicates for this particular URL what the type of page is and how you get to it. And then there's the domain. And the domain has two parts there. In the example that I have with whitehouse.gov, .gov is a generic top-level domain, and White House is a secondary domain. And these generic top-level domains are overseen through a company known as the Internet Assigned Names, the Internet Assigned Numbers Authority. the IANA, which works with ICANN to decide what top level domains are available. And then it's up to individuals to go out and seek a secondary domain. And there can also be personalized URLs that we'll talk about later on. If you are the White House, or if you are any particularly well-known, very well-known business, then you want your business or your indicator of origin to be your secondary level domain. An initial question that you have to ask yourself is, should that secondary level domain be protected in the law for every generic level domain? And so this has become an even more important question in the last couple of years, because generic level domains .gov, .com, .org, .net, there used to only be 22 of those back in the 90s. And then a couple of years ago, ICANN decided to cooperate with private businesses and allow for what I think of as a money-making venture, allow for anything to become a top-level domain if the entity paid an initial $185,000 US, and then additional fees along the way to secure a top-level domain. So you have top-level domains now that can be the business name, but .com is still the most popular generic top-level domain. And then you have secondary level domains that are just open to the creativity of the selector. Now, all domain names, no matter where, everything, as I said, is overseen by ICANN and IANA. And the entities that allow for an individual or company to select a domain name have standard registration agreements. And part of those registration agreements, as highlighted here, say that the party seeking to register the domain name will not infringe upon or otherwise violate the rights of any third party. So when a party is seeking to secure a domain name, they are attesting to the fact that they are not engaged in any trademark infringement. They're not taking anybody else's name. So let me look at turn you to some numbers here. The first .com domain name came out in 1985 for a company called Symbolics. Again, that was the first .com. And again, 1985, when computer usage and personal computers, that type of thing, weren't very prevalent. At the close of the fourth quarter of last year, the Domain Name Monitoring Association indicated that there were now 366 million domain names that are active. And so with that many active domain names, you're going to have some conflicts, some disputes. Another overriding agreement that anybody who registers a domain name, knowingly or unknowingly, clicks that they accede to is that if there's a dispute between domain names, then the process known as the Uniform Dispute Resolution, or UDRP, will be the first step in trying to resolve that conflict. And the very first UDRP that was overseen internationally, arbitrated, was in 1999 between the World Wildlife Federation and the World Wrestling Federation, both who claimed WWF as their secondary level domain. and wanted to stop the other entity from using WWF with any other top level domain. And again, as I said, initially there were 22. Now we literally have close to 2,000 generic top level domains available. Do we want to say legally that whoever uses WWF.com should be able to stop anybody else from using WWF anywhere on the internet? What type of regulations do we need in the future? Should we say that you can only register WWF, or should we have said back then that it had to say WWF wildlife or worldwildlife.com, and your other competitor there had to say worldwrestling.com? Should WWF be registered for, considered registered for all generic top level domain names when it's registered for one? When it was only 22 generic top level domains, that was fine. Many arbitrators and many courts didn't have a problem saying that if you registered, some famous name, WhiteHouse.com, then White House was considered protected for all of the other domains. It wasn't universally applied, but it was certainly easier for those arbitrators and judges at the time to accept. But now, with so many generic top-level domains, as that's evolved over the years, that has not been the case. Just some other examples here of the growth and the present status of domain names throughout the world. As I said, over 366 million, with over half of those being .com and .net. And here we have some of the most prevalent. This is just a little older, showing that 152 approximately million at that time were .com. This is a mix of different generic top-level domains. We see .com. You might recognize .net, .org, but they're also here mixed in some country codes. .cn, for instance, is China, which some of you might recognize. I don't know if anybody recognizes country for .tk. I know I didn't when I saw it initially. Thought it might be a typo because I thought it was for .tv. There are presently over 300 country codes, which is, I don't know why the authorities have allowed that to occur, because there are not 300 countries or nation states in the world. But nonetheless, some of them have become quite popular, and it was a way for a number of countries to make some significant amount of income. So .tk is not a typo. TK stands for the country of Tokelau, which is a small country in New Zealand. And the reason that it is one of the most popular generic top-level domains is that it's monitored and run in conjunction with the Netherlands, and they allow anybody to use it for free. So for those of you who want to, you can investigate and probably start up a domain name with .tk as the generic top-level domain. .tk isn't very catchy to me, even though some people have thought it meant TikTok, but it's not. I said earlier I thought it was a typo for .tv. Clearly, TVs have been prevalent in people's lifestyles around the globe for many decades. And TV is for a small Pacific island called Tuvalu. And Tuvalu actually sold their country code to VeriSign for somewhere in the nature of $10 to $15 million. So, there's some movement amongst domain names as far as country codes are concerned when we're talking about the generic top level domains. We have .ru, Russia, .br, Brazil, and so forth. And another graphic showing some of the growth in domain names, at least as far as country codes are concerned. Here's one that shows .in, which is the country code for India, and at 1.8% and growing. Obviously, a lot of these are tied to population. So you have Russia and China, and would expect India to have a lot of growth as well. So let's just look at, again, a comparison between trademark and domain names. I mean, a domain name can be a trademark if it is used distinctively to identify particular goods or services, but it's not automatically presumed to have trademark protection that might be outlined in state law. So trademarks, they are shared if they identify different goods or services. I know here, popular example we like to use is, Delta. Delta has been used and is currently used for airlines. People are familiar with Delta Airlines. Here it's popular with certain plumbing hardware. So Delta faucets, it's popular because it's a Greek letter and used with sort of Hellenic organizations, the Delta fraternity and so forth and so on. So they all use Delta, but they don't use the same representation of it. And it's for different goods or services. And trademarks in most places in the world can be acquired by use over time. If you want registration that allows you to exclude others from using the trademark, then there has to be government screening, and they have limited geographic enforceability. But if there's a violation, you can go to court, and there are remedies outlined in trademark statutes. Domain names, they don't have much in the way of any type of nation, state, or federal law, or common law is really what is used more so now. They are just for web addresses. It's cheap. There's just that affirmation from the individual that they're not infringing. There's no real oversight entity. They are given global coverage, though, because once you get that address on the web is accessible to anybody in the world. Excuse me. And there's only the administrative oversight. Looks like I'm a little bit stuck here in my presentation. All right, so we mentioned the agreement that the parties have, and we mentioned that UDRPs are present. They're not binding unless nobody's made an appeal within 10 days. And appeals are seldom made because they're cost prohibitive. You can get a domain name registered anywhere in the world. There are domain name registrars throughout the world. And if there is going to be an appeal, the appeal has to be in the location of the defendant respondent to the arbitration action, or it has to be appealed in the courts where the domain name was registered. So if I use a registrar in India and I file a case, which is mostly a paper case in the US, and then I don't like the decision, if I want to appeal, I have to appeal in India, and I'm not going to fly to India to appeal on a domain name. I'll just let that one go and register another one, because I can register a new domain name for fairly cheap. And when I say fairly cheap, we know that there are domain names that you can register for, just literally a couple of dollars. Going to court, also expensive here in the US. We're talking quarter to approaching $1 million if you want to file a trademark dispute. And with a UDRP proceeding, we're talking less than $15,000. And if an individual doesn't want to use attorneys, which they're not required to do, it'll be less than $5,000. You go through one of the authorized ADR providers. I've done cases for the Asian Domain Name Dispute Resolution, the National Arbitration Forum, and the World Intellectual Property. They all have arbitrators, as do the Arab Center and the Canadian International Internet Dispute Resolution Center, and the Czech Arbitration Court for internet disputes. So a person who wants to make a complaint against another party for using their domain name would file an action with one of these entities, and the case will be assigned to an arbitrator who has a minimum of 15 years experience, and the parties would submit their written claims to, if you're the claimant, indicate that the disputed domain name is identical or confusingly similar to the claimant's mark, and the respondent doesn't have any rights or legitimate interests, and in fact registered and used that disputed domain name in bad faith. Again, the UDRP proceedings are quick. From the time of filing to the time of the decision is 60 days or less. Cheap. And all the decisions are published on the internet, and either through their own, the 6 entities that I've indicated, they publish their own, and then ICANN publishes all of them. And they are globally accepted in the sense that everybody knows about the UDRP now and has been following it for more than 20 years. A lot of people don't like it, and you're not required to participate if you're an accused party. You don't have to respond. You can try and force the other parties to spend their time and money on it. The panels, they have to have experience in trademark law and preferably also domain names, but there's not a uniform set of qualifications. The decisions aren't uniform, and therefore they aren't binding on other UDRP arbitration decisions. There's no discovery. There's just the initial filings and then responsive filings to the complaints, and there's no damages available either. So it's very different than going to court. In the US, as I said, a domain name is allowed to become a trademark if it meets the standards of distinctiveness. And that is true in a couple of other countries as well. Again, I mentioned the IANA that works with ICANN. As I said, they indicated now that they've expanded to almost 1,600 top-level domains, and as of June of last year, 316 country codes. So we have a lot of availability out there for people to select domain names. a lot of potential for more conflicts. But if you recall the numbers I showed earlier, so far we've had only 70,000 plus cases go through these various UDRP proceedings. There are some available, some ongoing all the time, and we might think that's pretty good and moving pretty quick in 20 years. But again, looking at the number of domains out there, that's pretty small in proportion to the 366 million active domain names. Again, another example of the country codes. China tops it closely, followed by Tokelau, Germany, UK. These are the top 10 or so. India is just slightly below that, outside of the top 10. But India does have a process, as many of you may be aware, some of you may not be aware, that there's an in-country process for dealing with country code IN disputes, which is overseen by the National Internet Exchange of India, and was drafted in consideration of the Arbitration and Conciliation Act of 1996. And so it follows the same framework as the UDRP. It's called the INDRP, and it differentiates itself because it does allow an arbitrator there to award the cost of the proceedings against one party or the other. So the UDRP, you can cancel or transfer the domain name. You can do that under the INDRP as well, but also award the cost of the proceedings. That's at the discretion of the arbitrator or arbitrators. It's like the UDRP. There's either one arbitrator or a three-person panel. And you can see that it's been used and grown slowly. I didn't find the numbers for 2020, but you can see that just over 100 cases have been resolved in 2018 as well as 2019. Some of the big cases that were involving domain names in India, the first case, not necessarily an arbitration case, but the Titan Industries versus Gururaj and others. That case was the first case to afford trademark protection to domain names. And then we have Verizon with a big award when they sued for the unauthorized use of 663 similar Verizon trademarks. And one of our most animated popular individuals in our country, Don Trump, former President Donald Trump, who has tried to use domain names wherever he's been known to place hotels. So there were cases involving domain names Trump India and Trump Mumbai. Again, looking at the use of social media, we have Facebook, we all know of, Reddit, YouTube. Some of these are popular and throughout the globe, including in India. And I put these numbers up because you're looking at billions of people using Facebook and other types of popular social media. And when they do that, they use part of a domain name for that social media entity, but they also pick their own username. And so what we have is third level and fourth level domain names. And some of these can give rise to litigation. For instance, Chick-fil-A, which is known for the slogan, "Eat More Chicken," found out that a business called Eat More Kale also had a Facebook page, and they sued them for trademark infringement. Thankfully, I think they lost, but nonetheless, you can see that people will delve into this claims of trademark infringement over the use of domain names at at various levels where domain names are present: secondary, generic, tertiary. Now it's just called sometimes. And there's software to help people personalize URLs, and if people use these types of software, they have to be aware of the potential for a domain name dispute arising. All of the social media entities have their own individual sorts of intellectual property regulations. There is no standard for the internet, and there's no standard for social media. Whatever you are using as part of social media, you're automatically agreeing to their IP regulations. And here's just an example of one where anybody using Twitter says they're not going to engage in trademark infringement, and if they do, then their account will be suspended. So that would include your site on Twitter, the location of your site as indicated by your domain name. So while domain names arbitration disputes are small in comparison to the growth of internet use, it's an area of opportunity for people either to become arbitrators or to become skilled in representing complainants and respondents, because society and technology are moving us farther away from actually going to court. Arbitration has grown while litigation has reduced, and UDRP proceedings as organized through ICANN, INA. This is an example of private consumer-oriented international arbitration that's been very successful over the last couple of decades. If any of you have domain names, that's good. If you don't, you might consider trying to get them. I know they're available through registrars, as I mentioned, around the world. Here's an example where you can get them for a matter of a couple of dollars. And why have them? You might hit the jackpot. Some of these domain names that people secured were resold later on for, as you can see, millions and millions of dollars. So that is the extent of my comments. Any questions?
Yes, thank you, sir. Now we are asking all the questions. Yes, any participants? Yes, sure.
Very good morning, sir, from US, and very good evening from India, sir. So my question is pertaining to cyber squatting, wherein what happens is some of the infringers try to buy some buffer domains, and it is very difficult for the right holders to catch hold of these buffer domain holders, and therefore the cyber squatting which is done by them, it causes an irreparable pain, because under the WIPO the arbitration is the only method, because there is no damage which can be claimed. So how to resolve such issues when a domain has a dispute, no domain name has a dispute to it?
Well, I mean, I think that it is a difficult area, and that's why I say it's a good area for people to consider as far as IP law. When you have these cyber squatters, you have an interesting tension in the law, because as I showed you with my particular slide here, that some of these domain names can be resold for a large amount of money. But if there's a claim for cyber squatting, then the fact that you ask for more money than it costs to secure the domain name is often used against the complaining party. Uh, I think that if we want to see significant change uh, to address the area that you've asked about, what we need is for those parties who to join together and go to court and ask for judicial action. And then if there's positive law that's stated in the courts, then that can be put into future complaints as a leverage against individuals. The arbitrators, the different associations, which is led mostly by the the World Intellectual Property Organization, they try to come out with some standards, and they have frequently asked questions, and they call it the decision review. They started off with a basic one, then they went to 2.0, and now there's a 3.0. And you'd hope that people would reference that. But, it's not precedent. It's not something that any arbitrators have to follow, and courts don't have to follow it either. So it does make it difficult, but it also makes it exciting. I mean, it's something that can be changed through the strength of representation over time. That's the best answer I could give right now, I think.
True, sir. Thank you so much for that. Thank you.
Yeah.
Yes.
From any other participant? Yeah, sir. I have a question. Actually, the participant is not has joined in the Microsoft Teams, but he is viewing the webinar from a social media platform where we are making it live. He has posted the question in personal. Should I just read it out?
Yes.
Yeah. So actually, the question is, sir, you mentioned about injunctions which was passed against certain websites which were piracy related websites. So how far do you think the DMCA, the Digital Millennium Copyright Act, which provides for safe harbor to internet service providers, ISPs, or the intermediaries, how far it has been effective in USA?
Well, yeah, I mean, I think it's been very effective in the USA. It's flexible, so there's still ongoing disputes about it. But I think it's positive because, again, it allows the average citizen, the average consumer, a quick way of handling what they feel is an e-commerce problem, which is the unauthorized use for commercialization of something that they claim to have copyright protection in. And by that I mean, yeah, you can have an injunction, you can have a takedown of the offending information, and then there's a chance for a response, and all of this is done administratively and quickly without having to go to court. So you have a takedown notice, it's taken down, there's a time for response. If the response is adequate, it's put back up. If there is no response, it's put back up. But it's not forcing people to have to go into a deep pockets position right away to address something. So I think anything that allows for more private individuals to make use of legal standards, whether they be enforced through an administrative process or judicial process, I think those are good.
Thank you, sir. Any other question from any other participant? Yeah, so actually, yes, Shivram. Yes, Shivram, you can unmute your mic and ask your question.
I'm sorry, sir. Yeah. Sir, why can't be there a specific law under the international standard for dispute resolution for at least for domain name as specific as for a trademark or a particular for a copyright law? Why can't there be a specific law to that effect by WIPO?
Uh, why can't there be a specific law to that effect? I think because the nation, the state of the world is always been and continues to be a little bit fractured. We don't have them working uniformly to the extent that we do. We have treaties, but everybody doesn't select the treaties to be their law, so to speak. So even with TRIPS, which is covers 200 countries, it has 200 signatories to it, which represent pretty much all of the nation states in the world. It's still not the law in every nation, including in the U.S. There are parts of TRIPS that we don't adhere to, and you again can see some of that play out during this recent pandemic. Are we going to allow for many of the nations to have access to the vaccines, even though they can't pay any sort of patent-related royalties? That's happened before with medical issues, and the TRIPS agreement says right in there, flat out, that any type of patent rights can be suspended for matters of public health and addressed with compulsory royalties at a later time. But I guess the simple answer is that we can't get everybody in the world to see things through the same lens, even as it relates to domain names, especially as it relates to domain names. I think so. Another popular domain name is .co, and throughout the world, a lot of people use .co to indicate company as a shorthand for company. But once the country codes were issued, it was issued as Colombia's country code, and cha-ching for Colombia. So a lot of people look at ways to financially exploit things for themselves, and that's what prevents us having global laws to regulate these types of things.
Thank you, sir.
Yeah. Any other question from any other participant? Okay, so I suppose there are no questions from any participant, and thank you, sir, for accepting our invitation and presenting the topic, a complex topic, IP and e-commerce, and along with the domain names and the arbitration. So all these points have been effectively covered by you, and I suppose it basically helped all the participants, because as such the topic is a complex topic. You started from the basic, what is the different types of IPR, what is the foundation of IPR, the different kinds, and then you went into the intricacies of the topic, the interconnection between the topic, which actually helped all the participants. Now, as Dr. Singh is also here, actually, sir, we are conducting it is off the topic, it is not related to today's topic. As such, we are conducting a an e-certificate program along with a particular university. We have an MOU with them, and under that MOU, we are conducting a 3-month e-certificate program on ADR for all the students, for our students, as well as for students of other universities of India. So we would like to invite you as one of the speaker for this particular program.
Yeah. Okay. Well, just give me the details. I'm always glad to speak about ADR, and my experiences with it over the last 30 years or so. So, yeah.
We'll share the details. We'll share the official invitation letter with you soon. Just we wanted to informally have a word regarding that. Thank you. Now I request, now I would give the vote of thanks. First of all, I would like to appreciate today's expert, Professor Darryl C. Wilson, Professor of Stetson University School of Law, for accepting our invitation and gracing the event with your kind presence, sir. Thank you for mentioning the importance of intellectual property and how domain names affect intellectual property, along with how it is to be dispute resolved with the help of ADR mechanism. I'm also very much thankful to Advocate Mr. Hemant Bhai Patel, who is the president of the Sri Ramakrishna Seva Mandal, who has been a dynamic leader and has always shown us the path in law and always encouraged us to organize such events. I would also like to thank Srimati Josnaben K. Patel, Honorary Secretary of Sri Ramakrishna Seva Mandal. I would also like to thank Mr. M.B. Prajapati, Director, Anand Law College, for his inspiring mentorship. I would like to thank Dr. Rekha Kumari Singh, In charge Dean, Faculty of Law, Sardar Patel University, and In charge Principal, Anand College of Legal Studies. And also I would like to thank Dr. Amit Kumar Parmar, Principal, Anand Law College. I would like to thank all the participants for the patient listening. And finally, I would like to thank the technician for broadcasting this event on social media platforms. And we hope to accept and to again invite Sir for future events. Thank you, sir.
Well, that's great. I don't know if your school participates. I know we do have lots of, well, relatively speaking, a number of schools throughout India who have participated with our international environmental moot court competition. And so if you don't already, I'll share some additional information or get you guys connected to our faculty advisor for that as well, Professor Royal Gardner.
Thank you, sir. You can share the invitation and we'll circulate it among our students, and we'll ensure that we have a participation in that competition from our college. Thank you, sir. Now I would request Dr. Wilson to kindly leave the session. The session is. Thank you, sir.
All right. Thank you, everyone, for listening. And
thank you, sir. Thank you so much. Thank you so much, Professor Wilson. Thank you so much.
Thank you. Have a good evening.
Thank you, sir. Now I would request all the participants to kindly leave the session.